Well, here I am at St Catherine's College, Oxford, at the Society of Legal Scholars annual conference. Right, there I am. I gave my paper on Tuesday on Jersey bankruptcy law, so disaster and degrèvement, and the way in which those two procedures operate, mainly in relation to a run of recent cases involving Booth and the Booth litigants. But I thought I'd take this opportunity, whilst here in Oxford, to talk to you about the Equitable Maxims. And as you know, they're a series of principles, of ideas that exist to get across the general idea of what equity exists to do. Okay, so now we will discuss the Equitable Maxims. What are they? Well, as I've just explained, they're a series of maxims that embody the general principles of equity. So we could say that they're guidelines that illustrate the way in which the equitable jurisdiction is observed. That's according to Hanbury and Martin. So what we'll do now is go through some of the maxims and illustrate them by reference to case law or ideas to help put meat on the bones of the maxims. So the first one we'll consider is this: equity will not suffer a wrong without a remedy. So we will say, in relation to this maxim, that the best example is, of course, a trust. Because, as we know, at common law, a trust isn't enforceable, but we need equity to step in to ensure that the beneficiary is able to have their equitable rights pursuant to that trust respected. So the trustee is the legal owner, which common law would respect, of course, but equity will step in to enforce the equitable right. So when considering the maxim, equity will not suffer a wrong without a remedy, think about the enforcement of a trust. And perhaps deploy that in your assessment, that maxim in that context. Okay, the second maxim we'll consider is equity follows the law. So equity follows the law. We know that equity will not depart from statute, and similarly, it's only in exceptional circumstances that we will expect to see equity refusing to follow common law rules. However, there are occasions when it may divert, as we've just illustrated with the previous maxim. But to illustrate this equity follows the law, let's just think about Stack and Dowden for a second and the area of common intention constructive trusts. Well, in that case, you know, or will come to know, that the land was held jointly. So prima facie, we'd say that any equitable interests follow the legal interests, unless, like in Stack and other common intention constructive trust cases, a contrary intention is proved. So that was equity follows the law. Our next maxim that we will consider is he who seeks equity must do equity. So he who seeks equity must do equity. Well, here what we are considering, of course, is equitable relief, but in particular, equitable relief being extended to claimants who act fairly towards defendants in the future. So, for example, a case we might use for this is Chappell and the Times newspapers, where there were some employees who wanted to strike. So they were thinking about striking, but also they were after an injunction to restrain their dismissal, so to stop them being sacked, essentially. But because they, when they were thinking about striking, refused not to strike, we would not be particularly happy in extending the injunctive relief to them so as to ensure that they weren't dismissed. In other words, they should act according to the canons of equity in all of their dealings, particularly if they want to seek an equitable relief, such as an injunction. So he who seeks equity must do equity. Our next linked maxim is this. It's he who comes into equity must come with clean hands. So he who comes into equity must come with clean hands. And whereas our previous maxim, which we were considering, dealt with conduct that related to future conduct, that's to say, he who seeks equity must do equity, our clean hands maxim looks to the claimant's previous conduct. So, for example, equity will not grant relief of specific performance of a contract if a claimant is already in breach of his or her obligations. So that's previous conduct, though, by contrast. Our next maxim, delay defeats equities. So delay defeats equities. In other words, equity aids the vigilant and not the indolent. So a party who is delayed cannot obtain equitable relief. Many of these issues now are governed by the Limitation Act 1980, which deals, of course, with timing issues. And in particular, if you think about Section 21 of that statute, you'll see that any actions against trustees for breach of trust must be brought within 6 years. So that maxim, delay defeats equities. Bear in mind any time limits on litigation. Our next maxim that we will consider is equity is equality. So we've had equity follows the law. This one we're now seeing slightly different. Equity is equality. Namely, an equal division is the start point for equity where two or more people have an interest in property. And there's a very interesting case about a yacht called Roe and Prance on that, if you want to examine that maxim in action. So, equity is equality. On our next maxim, equity looks to the intent rather than the form. So, equity looks to the intent rather than the form. What we're mulling on here then is the idea that equity looks at the substance rather than the form. But of course, equity won't at the same time ignore formalities, as we know with the three certainties. And a good example of this maxim is, of course, the trust. Because even if the word trust isn't used, as Oakley demonstrates, for example, we can still have sufficient deployment of language that indicates an intention to create a trust. So equity looks to the intent rather than the form. Our next maxim, equity looks on that as done which ought to be done. So equity looks on that as done which ought to be done. So here what we're thinking about is the idea of a specifically enforceable obligation. And in particular one which will be treated by a court as giving rise to a position where the parties are treated as already being in a position that would allow performance of that obligation or cause performance of that obligation. So, for example, we might think about a specifically enforceable contract for a lease which creates an equitable lease. And the case for that is Walsh and Lonsdale, for example. or Attorney General and Reed, which we will encounter with our constructive trust examination later on in the term. Here, of course, we saw an individual who was obliged to hand over property pursuant to a constructive trust because the property belonged to the principal in equity. So equity looks on that as done which ought to be done. Our next maxim that we will consider is equity imputes an intention to fulfill an obligation. So equity imputes an intention to fulfill an obligation. In other words, equity will regard an act done which equates to another act as performance of that other act. So in my specific research field, if we think about debtors and creditors, if a debtor pays off a creditor using one source, but in fact they owed that creditor pursuant to another source, that will be a fulfillment of the obligation, that placating of that indebtedness. Okay, our next maxim is equity acts in personam. So equity acts in personam. And that's to reflect the idea that equity is personal in nature as a jurisdiction. So it exists to influence the body of the person, we might say. That's to say then, for example, if we were after an injunction and we obtained one and then that was breached by somebody, that's a contempt of court. So that's punishable by imprisonment. So we're thinking about equity acting in personam. So there are some of our main maxims. There are others, of course, such as equity will not aid a volunteer, or equity will not strive officiously to defeat a gift. That's another example. Or where the equities are equal, the first in time shall prevail. Or finally, where there is equal equity, the law shall prevail. So there are a number of maxims for you to think about and mull on. They're very important for the assessment in the sense of deployment like a secondary source. So where possible, do try and deploy the maxims and think about them as you're doing your general reading and thinking about equity. On which point then, I'll bid you goodbye. Enjoy your reading on the maxims in the set text or elsewhere. Until we meet again, goodbye.